All right, all praise, glory, and honor is most certainly due to the Most High. And I want to say peace to you in the name of His Son. I always count it a blessing each and every single time that I can come before you. And never do I count it as a light thing to do so. And there was just coming to you because I would be coming to you anyway, but I'm coming to you because there was the Supreme Court decision today, the ruling. It was a 9-0 majority decision, which basically was against some doctors who brought concerns about the use of the common abortion pill that was approved by the FDA. You know, I talk about abortion quite a bit because I believe it is and has been one of the greatest crimes against humanity. I believe in large part it is satanic. You are destroying ultimately life, and you are destroying the fruit of the womb that has the potential to be what Elohim is. And so I talk about it often, and for our people in particular, it has been catastrophic in regard to our numbers. We've aborted what would equate to approximately half of our current population in the United States. So I just wanted to read the court's decision, and I'll read some other things because it was really on a technicality. I actually went and read the entire Supreme Court case decision. Kavanaugh gave the opinion, and then Justice Thomas concurred. And I want to read some things, and then I want to read from a book that I wrote some years ago now called Killing Black Innocents, the Program to Control African American Reproduction from Slavery's End to the Present Day Self-Inflicted Genocide. You know, once I realized what abortion was doing to our people, you know, I was really moved by that revelation. So what I want to do right now, I want to read a couple things. Give me one moment here. I'll share my screen. Let's see. Oh, wait, that's not it. Hold on. Give me a moment. Okay. Let's see. Just want to read some things from this decision. Let's try it one more time. Okay. So the issue here with this decision, I'm just read it. Just to give us some context here. In 2000, the Food and Drug Administration approved a new drug application for mifepristone tablets marketed under the brand name Mifeprex for use in terminating pregnancies up to 7 weeks. Now, initially, you know, you had to go into the doctor's office, and you know, it was with supervision that this would be given. Okay, to help. Remember, I talked about how you know, some people likening this to getting the Underground Railroad now and getting access to this after the overruling of Roe v. Wade. But nevertheless, it said to help ensure that Mifeprex would be used safely and effectively, FDA placed additional restrictions on the drug's use and distribution, for example, requiring doctors to prescribe or to supervise prescription of Mifeprex and requiring patients to have 3 in-person visits with the doctor to receive the drug. In 2016, FDA relaxed some of these restrictions, deeming Mifeprex safe to terminate pregnancies up to 10 weeks, allowing healthcare providers such as nurse practitioners to prescribe Mifeprex and approving a dosing regimen that required just 1 in-person visit to receive the drug. In 2019, FDA, as if we can trust the FDA, Nevertheless, they approved an application for generic mifepristone. In 2021, FDA announced that it would no longer enforce the initial in-person visit requirement. Now, I've seen estimates of one in 25 end up having some sort of complication, but nevertheless, for pro-life, now here it is, for pro-life medical associations and several individual doctors moved for a preliminary injunction that would require FDA either to rescind approval of mifepristone or to rescind FDA's 2016 and 2021 regulatory actions. Danco Laboratories, which sponsors mifeprex, intervened to defend FDA's actions. You know, the fact that you would make a medication to do this and that it would be used as a form of birth control is troubling. Nevertheless, those are my words. Nevertheless, the district court agreed with the plaintiffs and in effect enjoined FDA's approval of mifepristone, thereby ordering mifepristone off the market. The FDA and Danco appealed and moved to stay the district court's order of pending appeal. As relevant here, the court ultimately stayed in the district court's order pending the disposition of proceedings in the Fifth Circuit and this court. Now, here's the issue. Okay, this is the issue, and it's kind of like you want to call it a technicality, but it says the plaintiffs lack Article 3 standing to, and it said that it said this to me. It was almost redundant over and over and over again. Plaintiffs lack Article 3 standing to challenge FDA's actions regarding the regulation of mifepristone. Article 3 standing is a bedrock constitutional requirement that this court has applied to all manner of important disputes. Okay, so in other words, you have to have standing, which they didn't have. And another thing is causation. But standing is, I'm gonna just read this part, read a little bit more. Standing is built on a single basic idea, the idea of separation of powers. Article 3 confines the jurisdiction of federal courts to cases and controversies. Federal courts do not operate in an open forum for citizens to press general complaints about the way in which government goes about its business. So in other words, because the FDA approves something, they're basically saying like you can't bring a case against them because you don't like it. If you weren't specifically or injured by it, you know, or it's you can't. So that's basically what they mean. Okay. Federal courts not operate in an open forum for citizens to press general complaints about the way in which government goes about its business. To obtain a judicial determination of what the governing law is, a plaintiff must have a personal stake in the dispute. So to establish, so this is basically why there was a 9-0 decision against the plaintiff, unanimous decision against the plaintiff. Let's see. I'm just go down a little bit. They said, because they were arguing, let's see, go back to one. Plaintiffs first contend the FDA's relaxed regulation of mifepristone may cause downstream conscience injuries to the individual doctors. Okay, so certain things that as a doctor, you're not required to do, like a doctor is not required to perform an abortion, even though so many are abortionists, which is, to me, obviously troubling if you're going to take a Hippocratic oath, besides the portion that honors a false deity, you're supposed to quote unquote do no harm. I don't see how that's the case if you're again these many abortions that are being carried out. Even assuming the FDA, well, let me scroll down a little bit more. I don't want to read all this. Plaintiffs next assert that they have standing because FDA's relaxed regulation of mifepristone may cause downstream economic injuries to the doctors. The doctors cite various monetary and related injuries that they will allegedly suffer as a result of FDA's actions, in particular, diverting resources and time from other patients to treat patients with mifepristone complications, increasing risk of liability suits from treating those patients, and potentially increasing insurance costs. But the causal link, and this is the issue, another, I said one is standing, other is causal, but the causal link between FDA's regulatory actions in 2016 and 2021 and those alleged injuries is too speculative, lacks support in the record, and is otherwise too attenuated to establish standing. Moreover, the law has never permitted doctors to challenge the government's loosening of general public safety requirements simply because more individuals might then show up at emergency rooms or in doctors' offices with follow-on injuries. Citizens and doctors who object to what the law allows others to do may always take their concerns to the executive and legislative branches and seek greater regulatory or legislative restrictions, because this is judiciary, so they interpret law. Okay. They don't make laws, supposedly. Now that's with that. But you know, I keep saying this. This country's on a downward trend. This country is morally bankrupt. It is morally bankrupt. And this is one of the issues that is one of the top issues in this next coming election. It has been, and you look back, this so-called, and I'm not saying vote Democrat or Republican. I'm not saying anything like that. I'm just saying that, you know, many people, particularly many women and some feminist men, I guess, will fight for a woman's right to so-called choose abortion instead of really being married and raising children. This is it's just so disturbing. It's kind of hard to put into words. But when it comes to the Supreme Court, it is not as if, you know, there's a higher law than the Constitution. That is Torah. Okay. And people act as if, you know, the Constitution, I mean, they're ruling according to the Constitution. This same Constitution, you know, the same body, the Supreme Court, also they ruled in the Dred Scott decision. This same court also you know, is responsible for the decision in Roe v. Wade, which led to the abortion of millions of people. So, you know, to act as if this is, you know, this is this technicality has a moral high ground. The reality is, foundationally, abortion is wrong. That's the whole problem. You should not be, because you can go through this, but clearly abortion is murder. This is, I want to read something here. Now, this is what I wrote in chapter 8 of this book, again, Killing Black Innocence. I'm going to just read a little bit. And I wrote this before, this is some years ago, before Roe v. Wade was ruled overturned. And because even, this is another side note, even with it being overturned, the year after it was overturned, there were more abortions the year after it was overturned than there were the year before it was overturned. That, again, America is morally bankrupt. And such a country as this, you cannot believe that judgment is not on the horizon. You know, and that kind of judgment is above, you know, the powers that be, the agencies and the branches of government. You know, where that judgment is coming from is beyond your pay grade. It's above the power that you possess right now to say, you know, to say and to do what you will. Eventually, your cup of iniquity reaches its brim. But now this is on page 70 of this book. It says, and this is chapter 8, why Roe v. Wade is unconstitutional. In a 7-2 decision, the United States Supreme Court handed down rulings that legalized abortion in America. Prior to the January 22, 1973 Roe v. Wade ruling and the lesser-known Doe v. Bolton ruling that was issued on the same day, abortion was illegal in almost every state. The regulations on abortion in states where the practice was legal prior to these landmark cases were removed after the court's ruling. Since 1973, there have been approximately 50 million abortions performed within the United States. Now, that was at the time that this book was written. You'll see how many, I'll show you how many there have been since then, since Roe v. Wade. All right, this chapter represents the reasons why Roe v. Wade is unconstitutional and should be overturned. So even before you get to Torah, you know, it was against the Constitution. So the one reason I give is it exceeded constitutional authority. The court exceeded its constitutional authority by making a law sanctioning abortion. Like I said, or like I read in that in the ruling, that, you know, if you disagree with something, you know, it said you could appeal to the legislative or executive branches. We're here because the judicial branch is not to make law, but they actually did that in this case. According to the U.S. Constitution, the power to establish laws vested in Congress and is retained by the state legislatures. Although the power of judicial review is not explicitly granted to the court by the Constitution, the authority to invalidate laws deemed unconstitutional has a long precedence that began with Marbury versus Madison in 1803. With this Roe v. Wade ruling, the High Court oversteps its role of determining if laws violate the constitutional rights of individuals. In this case, the court struck down laws it deemed not unconstitutional, but rather bad social policy. In 1982, Justice Burger expressed the standard of the court when he wrote, quote, irrespective of what we may believe is wise or prudent policy in this difficult area, the Constitution does not constitute us as quote unquote platonic guardians, nor does it vest in this court the authority to strike down laws because they do not meet our standards of desirable social policy, wisdom, or common sense. Now, the next one you hear a lot is so it exceeded constitutional authority. That was Roe v. Wade when it was first ruled upon. Then the right to privacy. The Supreme Court based its ruling on the right to privacy, which the court maintained was guaranteed by the Constitution. The court determined that while this right was not specifically mentioned in the Constitution, it was implied in either the 14th Amendment or the 9th Amendment. Okay, so they said the right to privacy it is implied. However, the court's finding that laws prohibiting abortion violated a woman's right to privacy is not mentioned in the text of the Constitution, nor is it implied. In his dissenting opinion, Justice Byron White correctly attests, quote, I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right to pregnant mothers and, with scarcely any reason or authority for its actions, invests that right with sufficient substance to override most existing state abortion statutes. The upshot is that the people in the legislatures of the 50 states are constitutionally disentitled to weigh the relative importance of the continued existence and development of the fetus on the one hand against the spectrum of possible impacts on the mother on the other hand. As an exercise of raw judicial power, the court perhaps has authority to do what it does today, but in my view, its judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court. Nevertheless, Justice Harry Blackmun argues in the majority opinion, quote, the right of privacy, whether it is found in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Now, all right, even the concession of an implied right to privacy is problematic because of its broadness. A right to privacy that is expansive enough to encompass the act of abortion is thus applicable to practically every illegality outside of public view. So, in other words, as long as you do it in private, you can't be held accountable for it. You invite somebody over to your house in your private dwelling, and you give them some steak, and then at the end of that steak, you take the steak knife and stab them in the chest. The police come knocking at your door. They say you got a dead body, and you can't say, "Well, no, this was done in the privacy of my own home." That's ridiculous. If this case is what other implied rights are there in the Constitution, furthermore, there's nothing private about an abortion. Justice Blackmun bonded the quote-unquote right to have an abortion with past court decisions that recognize privacy rights in the spheres of marriage, child rearing, procreation, and contraception use. That's Loving versus Virginia, Skinner versus Oklahoma, Meyer versus Nebraska, and Pierce versus Society of Sisters, and Griswold versus Connecticut with abortion. Marriage, child rearing, and procreation predate the laws of man and are inherent in the notions of liberty and the pursuit of happiness. Contraception use and abortion, although similar in terms of purpose, are not comparable in the realm of privacy. The latter is done outside of the confines of a marital bedroom. The court's use of the 9th Amendment to justify the unspecified right to privacy that is inclusive of the right to have an abortion contradicts the right to life retained by the people in the Ninth Amendment. Now, the next one is the question of when life begins. And pay attention to this. All right, it is logical to assume that for the court to determine the constitutionality of abortion, it first would have to settle the question of when life begins. Okay, now that's clear, because if you don't settle that, isn't it possible that you could be ending life before it actually begins, thus committing murder? So Blackman wrote, this is what he wrote: we need not resolve the difficult question of when life begins, when those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus. The judiciary at this point in the development of man's knowledge is not in a position to speculate to the answer. So that alone, if you can't determine when it is, you shouldn't be doing it. You should err on the side of caution. Perhaps it would be the terminating of a life. Now, considering the possible, now this is, I'm right, these are my words, considering the possible destruction of life, how could the judiciary ethically overturn laws legalizing abortion if it was uncertain of when life commenced? Furthermore, Blackman's assertion that no consensus existed concerning the issue of when life begins, at least in the areas of science and medicine, is simply untrue. So what he said was false. In a Senate Judiciary Committee meeting on the Human Life Bill, the committee summarized the issue of when life begins as follows, quote, physicians, biologists, and other scientists agree that conception marks the beginning of the life of a human being, a being that is alive and is a member of the human species. There is overwhelming agreement on this point in countless medical, biological, and scientific writings. Okay, so that's people know that. Even, scientists have found even when at the moment of conception, there's a light that actually, there's a light at that very moment. They captured that. This is known. It was known back then. The next one is the Supreme Court assumed the role of legislature in establishment of trimester framework. They came up with that. I'm gonna keep reading. Bear with me. Blackman can claim that it was unnecessary to speculate on when life begins, but does just that with his trimester framework. By establishing a trimester framework, the court assumed the role of a legislature. Again, the court extended its constitutional authority according to Article 6, Section 2 of the U.S. Constitution. This arbitrary trimester framework, which you hear trimester all the time, that term, stipulated the following. 1, the state may not regulate abortion for any reason during the first trimester when the privacy interest of the mother is the strongest. 2, during the second trimester, state regulation could only order to protect the woman's health. 3, in the third trimester, the state may regulate or prohibit abortion to protect the potential life of the child, except when abortion is necessary to preserve the health or life of the mother. In the majority opinion of Webster v. versus Reproductive Health Services, Supreme Court Rehnquist denounced this arbitrary trimester framework. He stated, quote, the key elements of the Roe framework, trimesters, and viability are not found in the text of the Constitution or in any place else one would expect to find a constitutional principle. The result has been a web of legal rules that have become increasingly intricate, resembling a code of regulations rather than a body of constitutional doctrine. As Justice White puts it, the trimester framework has left this court to serve as the country's ex officio medical board with powers to approve or disapprove medical and operative practices and standards throughout the United States, unquote. Unbeknownst to many Americans, in Roe v. Wade's companion case, Doe v. Bolton, the Supreme Court ruled that the state could not deny a woman's right to have an abortion after viability if abortion was deemed necessary to protect the health of the mother. The court defined health as follows, quote, all factors, physical, emotional, psychological, familial, and the woman's age relevant to the well-being of the patient, unquote. The use of this broad definition extended the right to have an abortion upon request during any month of pregnancy. Next thing, misinterpretation of history. The Supreme Court's ruling that the unborn are non-persons was largely influenced by an inaccurate historical interpretation of abortion. According to the historical observation of the court, abortion was not a punishable crime from the earliest time of common law until the 19th century. And abortion laws passed during the 19th century were ratified for the health of the mother, not the unborn child. Blackman wrote, quote, "It is undisputed that at common law, abortion performed before quickening, the first recognizable movement of the fetus in utero, appearing usually from the 16th to the 18th week of pregnancy, was not an indictable offense," unquote. Now, many legal scholars have pointed out that quickening, the moment in which the woman feels the movements of the child in the womb, was an evidentiary test for the crime of abortion because this was the only method to ensure that a pregnancy did in fact exist because there were no pregnancy tests at the time. This did not mean, as the court implies, that the unborn child was not considered a living human being. Blackman based the erroneous historical analysis on the thesis of Cyril C. Means Jr., who was at one time the general counsel for the National Association for the Repeal of Abortion Laws. To claim the abortion was not a crime in common law Means had the arduous task of refuting Edward Coke, who regarded abortion as a quote, great misprision, unquote. To support his position, Means uses the dismissals of abortion charges in two cases, the twin slayers case and the abortionist case. However, it is more probable that these dismissals were a result of an inability to prove guilt, not the lawfulness of abortion. Kind of like here, even in this case, this was like a technicality. This was like you have to establish standing before you do anything else. As it said, I didn't read all of that, but one portion of it, it talked about you have to determine, in other words, how are you affected by it? It can't be as general as it was presented, according to them. The court, in essence, charges Koch with creating the crime of abortion. This is an example of how history is distorted. The court concluded, quote, "It now appears doubtful that abortion was never firmly established as a common law crime, even with respect to the destruction of a quick fetus. The court frames the differences in common law pre-post quickening abortions to mean that common law allow women the latitude to abort their children during the early months of pregnancy." Now, that's not the case, especially as even though their religion was, they still had some form of religion, okay, at this time. This was not something that they were doing just legalizing abortion. Nevertheless, the court frames the differences in common law pre-post quickening abortions to mean the common law allow women the latitude to abort their children during the early months of pregnancy. The truth of the matter is that the unborn were protected under common law. At the time, medically, it was not necessarily accepted that life commenced at the moment of conception, and certainly could not be proven before the time of quickening. That's like the fluttering in the belly. However, the unborn were protected by the law even when the predominant thought was that life began at the moment of quickening. Blackstone wrote, quote, "Life is the immediate gift of God, a right inherent by nature in every individual, and it begins in contemplation of law as soon as the infant is able to stir in the mother's womb. For if a woman is quick with child, and by a potion or otherwise killeth it in her womb, this, though not murder, was by the ancient law homicide or manslaughter. But at present, it is not looked upon in quite so atrocious a light, though it remains a very heinous misdemeanor. The discovery of the ovum in 1827 proved that conception was the beginning of life, not long after the term quick with child became synonymous with the moment of conception. In 1837, Parliament ratified an abortion statute that was void of an evidentiary requirement and made abortion at that time punishable by law. This scientific advancement led to the protection of the unborn at any stage of pregnancy. Notwithstanding, the court provided a distorted perception of common law that implies that a lack of prosecution equates to legal right. To support the fallacy that, quote, few state courts called upon to interpret their laws in the late 19th and early 20th century did focus on the state's interest in protecting the woman's health rather than in preserving the embryo and fetus, unquote. Blackman cited one 1858 New Jersey case The court ignores the fact that the circumstances surrounding an illegal act impacts the punishment for that crime. For example, lesser punishment for the crime of murder committed by an individual deemed legally insane. This lesser judgment does not indicate that a particular act is legal, but this is just what the court implies in its interpretation of the New Jersey case. In addition, the court also ignores the numerous court decisions of the same time that explicitly affirm and others that imply that abortion statutes were for the protection of the unborn. Okay, people need to really consider why they would rule in such a way and who this would impact it and who has it impacted. The next reason, the unborn as non-persons and the use of the 14th Amendment. Blackman's statement, quote, the unborn have never been recognized in the law as persons in the whole sense is, unquote, is reminiscent of a time in American history in which individuals were arbitrarily deemed as non-persons or not fully human. In the Dred Scott versus Sanford 1857 case, the Supreme Court ruled that persons of African descent brought into the United States as slaves and their descendants were not protected by the U.S. Constitution and were not citizens, nor could they ever be. Thus, the court ruled that Scott was not a citizen within the meaning of the U.S. Constitution at the time of its adoption. The majority opinion written by Chief Justice Taney stated the following, quote, they had far more than a century before being regarded as beings of an inferior order, altogether unfit to associate with the white race, either in social or political relations, and so far inferior, they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit, unquote. The contrariness of the court's decision in the case of Roe v. Wade is quite telling in its use of the 14th Amendment. The broad definition of citizenship in the Citizenship Clause of the 14th Amendment partially overruled the Dred Scott v. Sanford decision, which held that blacks could not be citizens. It is ironic that the amendment used to overrule the Dred Scott decision, which held that blacks were non-persons and consequently non-citizens, was utilized in Roe v. Wade to treat the unborn as, quote unquote, beings of inferior orders who have no rights, which the born are bound to respect, unquote. Consider the similarities in each decision. So I'm going to compare the Dred Scott decision versus Roe v. Wade that rendered blacks and unborn as unpersons or non-persons. Citizens and persons do not apply to African Americans and the unborn. In the Dred Scott decision, it said, quote, a Negro whose ancestors were imported into this country and sold as slaves were not intended to be included under the word citizens in the Constitution and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States, unquote. What was said in Roe v. Wade? The word person, as used in the 14th Amendment, does not include the unborn. The unborn have never been recognized in the law as persons in the old sense, unquote. The right to privacy. In the Dred Scott decision, it said, quote, a slave is the property of the master and the Constitution has provided for the protection of private property in the law as persons in the whole sense, unquote. What does it say about right to privacy in Roe v. Wade? Quote, this right to privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy, unquote. Historical justification for slavery and abortion. In the Dred Scott decision, it said, quote, the Negro might justly and lawfully be reduced to slavery for his benefit. In Roe v. Wade, there is also the distress for all concerned associated with the unwanted child, and there is the problem of bringing a child into a family unable psychologically and otherwise to care for it. The Roe v. Wade decision is perhaps, now these are my words, the Roe v. Wade decision is perhaps the most egregious Supreme Court judgment in U.S. history. This is particularly true in regard to its impact on African Americans. But perhaps this was not by accident. Perhaps it was the court's intent to be platonic guardians, indeed, and pass a type of legislation that will lead to the culling of certain populations. Like I said, you need to ask the question, why do they allow this? Like, for example, you have to ask the question, why are they allowing millions of people to come into the country, just walk over the border? Why people need to ask these questions. Why would they legalize abortion? Perhaps it was the court's intent to be platonic guardians, indeed, and pass a type of legislation that would lead to the culling of certain populations. In a 2009 New York Times Magazine interview, Supreme Court Justice Ruth Bader Ginsburg stated that during the time of Roe v. Wade, she assumed that the controversial case would be used to allow Medicaid funding for abortions in order to curtail the numbers of populations that were considered undesirable. It would be naive to believe that the Supreme Court's decisions are solely based on constitutionality or unconstitutionality. Take, for instance, the Brown v. Board of Education decision that declared separate public schools to be unconstitutional. The court was made aware that school integration was an important factor in maintaining American world dominance. The Justice Department maintained that racial segregation had, quote, an adverse effect upon our relations with other countries. Racial discrimination furnishes grist for the communist propaganda mills, and it raises doubts even among friendly nations as to the intensity of our devotion to the democratic faith, unquote. So as a means of national security, and this is in 1954. This is at a time of a Cold War. Okay, so the Soviets could use that and say, look at America and how it treats black people. Black people have been pawns in this game for a long time, just like black people are being rolled out right now as whores for the Democratic Party to attack Trump, President Trump. That's you're a bunch of whores, okay? Political whores. All right. Let's see, where was I? Brown versus Board of Education was bigger than black and white children being educated in the same classroom. It was a matter of, at least in part, combating the spread of communism. Perhaps Roe v. Wade, as Justice Ginsburg stated, was at least in part a matter of population control. And what has been the effect of this? Let's take another look at something here. So if we let's just look at the numbers here overall. So today there have been 2,200, almost 3,000, 2,295 abortions in the United States. Since Roe v. Wade, there have been 65, almost 66 million abortions. Okay. This year, we're coming up halfway through the year, and there's been 400,000 abortions. Worldwide, since 1980, there have been 1,738,000,000 abortions. Now, and notice here where it says black babies since Roe v. Wade, since 1973, there's been roughly 20 million abortions. 20 million abortions. There are only approximately 40 million black people in this country, but there are roughly 20 million abortions. So we've aborted 20 million. That's approximately half of our current population. Think of Ginsburg. Hopefully Ginsburg's words are ringing your head, what I read when she assumed that that the controversial case Roe v. Wade would be used to allow Medicaid funding for the abortions in order to curtail the numbers of populations that were considered undesirable. This is a type of culling. I want to show you something else. Because quite frankly, if you're black, the reality is somebody wants you dead. Okay? Now, this is from usafacts.org. So you had six, and this is, it says in 2021, the Center for Disease Control and prevention. They keep these numbers, as does Guttmacher, okay, which is a tentacle of Planned Parenthood. But they said they reported a total of 625,978 abortions from 46 states. See, that's not all states. And Washington, D.C., this is a 0.9% increase from 2021. Okay, but it's 10% drop since 2012. Okay, now, because you used to have like you would see where it'd be 1 million a year. But now if you go to 20, if you look at this right here, you look at the time frame 2021, and sometimes these are 21. Do you understand there were 42% of all abortions in the United States were Black abortions? Wrap your head around that. 42% of abortions in 2021 were Black abortions. Black people are only about 12 to 13% of overall population, but having 42% of the abortions. Overall, we've had over a third of all abortions, roughly. Close to that. You have to consider why that's the case. And the fact that you would still argue tooth and nail to kill your progeny speaks to the reality that feminism today has created the worst women in the all of human history, and some of the weakest men in all of human history to support abortion. And it also speaks to the moral decay of the country as a whole, and it speaks to, because there is no uproar amongst the so-called ministers and pastors, it speaks to their moral depravity. It speaks to a group of people who are without spines, who lack testicular fortitude, who do not truly care about the people. Because if you really cared about the people, you would not be silent with all this bloodshed. This is comparable to the sacrificing of children, what you read about in the Bible, when they offered them to Molech. These children today are being sacrificed on the altar of convenience. Let's go to Psalms 127 and see what children are. And I talk about this often because we need to hear it. It says in verse 3, "Lo, children are an heritage of the Lord, and the fruit of the womb is his reward." So children are a blessing. As arrows are in the hand of a mighty man, so are children of the youth. Happy is the man that hath his quiver full of them. They shall not be ashamed, but they shall speak with the enemies in the gate. One more place, Exodus 21. Because as I stated, there was a law that's higher than this Constitution, right? So this is, let me read this to show you that there's a higher law. You know, for all this is because a lot of what you see in, the question is what makes America legitimate? It's power. Then they don't have a moral ground to stand on. And what's happening today is it's losing legitimacy worldwide, and people are not believing in the lie, okay? In the facade. It's being wiped away. That's not by coincidence. I think the leadership that you have right now is frail, in its frailty, and the leadership in its ineptitude. It is a immoral depravity. It is the leadership is symbolic of the entire nation. It is symbolic of the entire nation, what you see coming out of the highest office in the land. But now I want to read this here just to show you about law. This says, and this is Exodus 21:16, and he that stealeth a man and selleth him, or if he be found in his hand, he shall surely be put to death. That's what this country did to black people. What? It stole the man, kidnapped him, and enslaved him. This is what America has done. All right. But now I want to read, let me read this here. This is also in Exodus. This is before I read that, give me 1 second. I may want to read something else. You know what? I'll just read this. This is Exodus 21 and verse 22. It says, if men strive and hurt a woman with child, meaning she's pregnant, so that her fruit depart from her. In other words, these two men are engaged in a physical altercation, and one of them causes, however, it happened, he caused this woman to go into premature labor. Perhaps he, in the process, he ran into her. She hits the deck, and then now the stress causes her to go into premature labor. So it says, if men strive and hurt a woman with child, so that her fruit depart from her, and yet no mischief follow. In other words, even though she goes into premature labor, the baby is not harmed and she's not harmed, right? It said he shall surely be punished. He shall be surely punished according as the woman's husband will lay upon him. He shall pay as the judges determine, not the Supreme Court judges, because they judge according to the Constitution, but there's a law higher than the Constitution. And that's why people that know better need to not be silent with all this foolishness going on. They silent in the midst of the transgenderism that is plaguing the youth. They're silent with the LGBTQ agenda. It is an agenda. They're silent in the case of all these children being aborted. What do you think is going to happen to this country in your silence? You're literally butchering. You're literally butchering people that are mentally ill, that are spiritually ill. But nevertheless, it says, and if any mischief follow, notice what it says here, then thou shalt give life for life, eye for eye, tooth for tooth, hand for hand, foot for foot, burning for burning, wound for wound, stripe for stripe. What does that tell you? That's telling you that in the womb is life. So if it in that life is not a non-person, it is a person with rights. And since there is sanctity, see, even the death penalty for murder, for example. And I understand Jesus said he who was without sin, let him cast the first stone, because they were dealing in unrighteous judgment. They caught a woman in adultery, they didn't bring the man, right? And they were so sinful, they're in no moral position to carry out such judgment. But what does this imply? Life for life. That implies that life in the womb has just as much value as life outside of the womb. Okay? And it is really asinine to say that is not life. Any embryologist will tell you that life begins even at conception. So, and any argument that some may say, well, it can't survive on its own, as if the child even outside of the womb can survive on its own, even as if sometimes when you get up in age, you don't need a little assistance, or if somebody's born with a birth defect, or some accident happens and they need help to survive, that's still life and there's sanctity there. So I just wanted to touch upon that and remind you that we're at the House of the Faith, meet every Sabbath at 5925 West 25th Avenue in Gary, Indiana at 1 p.m. Central Standard Time. We live stream right here on the Israel Teach YouTube channel. We also meet our Stafford, Virginia congregation meets at the Red Roof Inn in Stafford, Virginia. The address is 153 Garrisonville Road. Again, Stafford, Virginia, and we meet at 12:30 p.m. Eastern Standard Time. And with that, brothers and sisters, I want you to consider these things because, there's a lot of blood in the hands of America, this body, the Supreme Court is culpable. Even not, if you don't say not this case, certainly in this ruling on Roe v. Wade. That's something that people need to really consider, and you need to consider what will be the consequences for such moral depravity. I thank you for your time.